Case 1, Dixie Denise Villa. February 24, 2019. First Circuit Court, Honolulu, Hawaii. Dixie Denise Villa presented herself to the families of Honolulu Military Reservation as a trustworthy caregiver. She ran what she described as a home daycare, a warm and supervised environment where working parents could leave their youngest children in safe hands while they reported for duty or headed into long overnight shifts. She was not a stranger to the community. She was a neighbor. She was familiar. And that familiarity, that sense of comfort and trust, is precisely what made what happened on the night of February 24, 2019, so devastating for everyone who had ever placed a child in her care. Honolulu Military Reservation sits on the island of Oahu, nestled within the broader Honolulu district, a tightly knit residential community where military families build temporary lives far from home. The parents stationed there rely heavily on one another and on trusted civilians within the community to help manage the demanding rhythm of military family life. Childcare is not a luxury for these families. It is a necessity. And when someone within that circle offers their home as a place of care, parents are inclined to believe in good faith that their children will be safe. Abigail Lobish was 7 months old. She was an infant in every sense of the word, entirely dependent, entirely trusting, entirely unable to advocate for herself or signal distress in any language that adults around her might have immediately understood. Her parents had arranged for her to spend the night in Villa's care, a routine overnight arrangement that was supposed to be unremarkable, the kind of childcare handoff that military families execute dozens of times each year without incident. Abigail was dropped off. Her parents went about their obligations. They expected to return to a healthy baby girl. They did not. When Abigail Lobish was found unresponsive, investigators and medical personnel responded immediately. What the medical examination revealed was not accidental. It was not the result of an unforeseen illness or an unexplained sudden infant health event. What medical professionals identified in Abigail's system was a lethal concentration of diphenhydramine, the active pharmaceutical compound found in the over-the-counter antihistamine commonly known as Benadryl. In an adult, a dose of diphenhydramine produces drowsiness. In a 7-month-old infant, a quantity sufficient to reach lethal levels in the bloodstream is not an accident. It is not a misunderstanding about pediatric dosing. It is, in the words that would eventually be used in the court proceedings that followed, a criminal act. Investigators began the process of understanding what had happened inside Villa's home that night. The picture that emerged was deeply troubling. Villa had been operating her childcare arrangement without a license. She was not a certified daycare provider. She had no formal credentials, no state-approved oversight, no regulatory checks on her conduct or her environment. She was simply a woman who had positioned herself as a caregiver within a community that needed one, and she had done so outside the legal framework that exists precisely to protect children from harm. The investigation into Abigail's death was thorough and methodical. Prosecutors built their case around the toxicological evidence, the operating circumstances of Villa's unlicensed facility, and the facts surrounding Abigail's final hours. The evidence was compelling. The conclusion drawn by investigators and ultimately accepted by the court was that Villa had administered diphenhydramine to the infant, a substance with no legitimate medical application in a 7-month-old without physician direction, a substance that in the quantity found in Abigail's system had caused the child's death. Dixie Denise Villa was charged with manslaughter. The case moved through the First Circuit Court in Honolulu, and the proceedings were followed closely by the military community on Oahu and by child safety advocates across Hawaii. Villa was ultimately convicted and brought before the court for sentencing. On May 7, 2025, the court handed down its judgment. Dixie Denise Villa was sentenced to 20 years in prison. That sentence represented the maximum penalty available under the manslaughter conviction, the court's clearest possible signal that what Villa had done to Abigail Lobish was not a lapse in judgment, not a moment of carelessness, but conduct serious enough to warrant the full weight of the law. 20 years. The maximum. For a 7-month-old girl who had been placed in her care. The Lobish family had trusted the military community's informal networks to help them find care for their daughter. What they found instead was a woman operating outside the law, in a setting with no oversight, making choices that no licensed, trained, or regulated caregiver would ever make. Abigail never had the opportunity to grow, to learn to walk, to speak her first words, to experience the world beyond the first 7 months of her life. She was taken from her family in the place that was supposed to keep her safe. The sentencing in May of 2025 brought a measure of legal closure to the Lobish family and to the broader Aliamanu community. But it also reignited a conversation that advocates had been having for years about the regulation of unlicensed childcare in Hawaii and across the country. Every state in the nation has licensing requirements for childcare providers for a reason. Those requirements exist not to create bureaucratic hurdles, but to create a layer of protection around the most vulnerable people in any family, the children. When those requirements are bypassed, when parents are kept in the dark about the unlicensed status of the person caring for their child, the consequences can be irreversible. Abigail Lobish deserved protection. She deserved a caregiver bound by law, by training, and by ethical obligation to keep her safe through the night. She deserved to be returned to her parents in the morning, healthy and whole. The system failed her because someone chose to operate outside of it. And in the years since her death, child welfare advocates in Hawaii have continued to push for stronger enforcement of childcare licensing laws, more accessible resources for military families seeking verified care, and a culture of accountability that leaves no room for unlicensed operators to build trust within communities without scrutiny. Justice was delivered in Courtroom 1 of the First Circuit Court on May 7, 2025. Dixie Denise Villo will spend 20 years behind bars. But the more enduring memorial to Abigail Lobish is the ongoing work of the advocates, the parents, and the community members who refuse to let her story be forgotten, who insist that every child placed in someone else's care deserves to be protected by every safeguard the law can provide. Abigail Lobish was 7 months old. She mattered. Her life mattered. And the accountability the court delivered in her name matters too. If you or someone you know has concerns about unlicensed child care or child safety in your community, the Child Help National Child Abuse Hotline is available 24 hours a day, 7 days a week at 1-800-4-CHILD. You do not have to have certainty to make a call. Concern is enough. If this case moved you the way it moved so many people in the Aliamanu community, please take a moment to like this video and subscribe to Cold Case Hour. Your support means that stories like Abigail's continue to be heard. Case 2, Jaylin Kema. Circa June, 1997. First Circuit Court, Honolulu, Hawaii. There are cases in the history of Hawaii's criminal justice system that linger in the public memory not because of their complexity, but because of their simplicity, because the facts, when laid out plainly, refuse to be processed as anything other than a profound failure of the one relationship that should be most protective of a child. The case of Peter Boy Kema Jr. is one of those cases. It has been discussed in Hawaii courtrooms, in child welfare policy circles, and in the homes of families across Oahu for more than 2 decades. And yet the essential tragedy at its center remains unchanged by time. A little boy needed his parents, and his parents were not there for him in the way that the word parent is supposed to mean. Peter Boy Kema Jr. was 6 years old when he was last seen alive in approximately June of 1997. He lived on Oahu, within the jurisdiction that would eventually bring his parents to account, though that accounting would not come for nearly 2 decades. He was described by those who remembered him as a small, lively child, the kind of child whose absence from a neighborhood, from a school, from a community, should have been noticed and investigated far sooner than it was. That it was not investigated promptly is itself a part of this story, a part that speaks to the systemic gaps in child welfare oversight that allowed Peter Boy's disappearance to go unacknowledged for years. Peter Boy's parents were Jaylin Kema, his mother, and Peter Kema Sr., his father. What eventually emerged from the investigation and prosecution of this case was a portrait of a home in which a child had been subjected to conditions that no child should ever experience. Conditions that resulted in severe physical harm that went untreated, that worsened over time, and that ultimately proved fatal. According to the admissions made during the legal proceedings that would eventually follow, Peter Boy died from septic shock, a condition that develops when untreated infection spreads through the body and overwhelms its ability to sustain itself. Septic shock is not instantaneous. It is not the result of a single moment. It develops over time, in a child who is suffering, in a child who is not receiving medical care, in a child who is depending entirely on the adults around him to recognize that something is wrong and to seek help. No help was sought, and Peter Boy did not survive. For years after his disappearance, Peter Boy's fate was not publicly known. There was no reported investigation. There was no missing child report that triggered the kind of community response that might have brought answers sooner. The child simply vanished from the visible world, and the adults who should have accounted for his whereabouts did not do so in any way that reached the attention of authorities. It was not until much later, through investigative and legal processes that are part of the court record, that the full circumstances of his death began to come to light. The legal proceedings that followed were long and complicated. The case wound its way through Hawaii's court system across multiple years. Jaylin Kema, Peter Boy's mother, eventually entered a guilty plea to manslaughter in 2016, nearly 19 years after her son was last seen alive. Her sentencing took place in 2017. The court, having heard the facts of the case, sentenced Jaylin Kema to 1 year in prison, a sentence she had already effectively served, and 10 years of probation. The sentencing reflected both the plea agreement reached with prosecutors and the legal complexities that had accumulated over the nearly 2 decades between Peter Boy's death and the resolution of the case. The outcome of Jaylin Kema's case prompted significant public discussion in Hawaii. Child welfare advocates, legal scholars, and community members all weighed in on what the sentence said about the state's ability to deliver justice in cases where the death of a child is not discovered, investigated, and prosecuted in a timely manner. The passage of nearly 2 decades between the crime and its legal resolution created evidentiary and procedural challenges that fundamentally shaped what the court could ultimately impose. That is a reality the legal system must grapple with, and one that makes the ongoing work of child welfare enforcement, the timely identification of children at risk, all the more critical. Peter Kema Sr. was also part of the legal proceedings, though the details of his case unfolded along a separate path. The court record reflects the roles of both parents in the circumstances that led to Peter Boy's death and in the aftermath that followed. Jaylin Kema did not live to complete her period of probation. She passed away from natural causes in January of 2019, approximately 2 years after her sentencing. Her death closed one chapter of a legal case that had stretched across decades, but it did not close the broader conversation about what Peter Boy's story means for child protection in Hawaii. What the case of Peter Boy Kema Jr. demands, more than anything else, is that every community takes seriously its collective responsibility to the children within it. Children cannot advocate for themselves in the legal or institutional sense. They cannot file reports. They cannot call for help in ways that systems are designed to receive. They depend entirely on the adults around them, parents, neighbors, teachers, community members, to see them, to check on them, to ask questions when they disappear from sight. Peter Boy disappeared from sight, and for too long, no one asked the right questions loudly enough. His story became part of the foundation of child welfare reform discussions in Hawaii. It contributed to ongoing conversations about mandatory reporting obligations, about the responsibilities of community members when children in their neighborhoods are no longer visible, and about the legal tools available to prosecutors in cases where the timeline between harm and accountability is measured not in months, but in years. Peter Boy deserved protection. He deserved medical care when he was suffering. He deserved to be seen by the adults whose job it was to see him. The court ultimately held his mother accountable in the only way the passage of time and the structure of the law allowed. But the truest accountability, the kind that honors a 6-year-old boy's memory most meaningfully, is the ongoing commitment of every adult in every community to pay attention, to ask questions, and to make sure that the children around them are safe. Peter Boy Kema Jr. was 6 years old. He deserved so much more than he received, and his story deserves to be remembered not as a cold case footnote, but as a living, breathing reason to do better for every child who comes after him. If you found this case important to know about, please like this video and subscribe to Cold Case Hour. Every subscription tells us that you believe these children's stories deserve to be heard. Case 3, Janae Perez and Ashleigh Utley. June 13, 2024. First Circuit Court, Honolulu, Hawaii. On the afternoon of June 13, 2024, emergency responders were called to a townhouse in Kapolei, located on the western side of Oahu within Honolulu County. What they found when they arrived at that address would be described in the subsequent court record as one of the most distressing child welfare situations encountered by investigators in recent years. Inside that townhouse, a 3-year-old child named Sarai Perez Rivera was found unresponsive. Efforts were made to revive her. They were not successful. Sarai Perez Rivera was pronounced deceased at the scene. She was 3 years old. The medical examination that followed provided investigators with the clinical foundation for what would become a murder indictment. The cause of Sarai's passing, as determined by the medical examiner, was dehydration and starvation. She had not received adequate food or water. She had not received the basic sustenance that a child's body requires to function, to grow, to survive. The condition of her body at the time of her discovery told a story not of sudden crisis, but of prolonged deprivation, a pattern of neglect that had unfolded over a period of time significant enough to produce the fatal outcome investigators documented. Sarai Perez Rivera lived with her mother, Janae Perez, and her mother's partner, Ashleigh Utley. These were the two adults responsible for her care in the Kapolei townhouse. These were the two adults who prepared her meals, who managed her access to water, who determined the conditions of her daily life. Investigators, in building their case, focused on reconstructing the circumstances of Sarai's final weeks, the patterns of life inside that townhouse, the resources available in the home, and the decisions made by the two adults who shared responsibility for her well-being. What law enforcement documented was a child who had been failed in the most fundamental possible way. The basic duties of caregiving, feeding a child, providing water, ensuring that a small human body receives what it needs to sustain itself, are not complex. They do not require special training or education. They are the most elemental expression of what it means to be responsible for a child. And in the Kapolei townhouse, those duties were not performed. Sarai Perez Rivera was 3 years old, entirely dependent on the adults in her home, and those adults did not provide what she needed to live. Janae Perez and Ashleigh Utley were arrested and charged in connection with Sarai's death. The investigation by Honolulu law enforcement and the subsequent review by prosecutors built toward a grand jury proceeding that would determine the formal charges to be brought against both women. In March of 2025, approximately 9 months after Sarai's death, the grand jury returned indictments. Both Janae Perez and Ashleigh Utley were indicted for second-degree murder. Second-degree murder in Hawaii does not require the state to prove premeditated intent in the narrow sense. It requires the state to prove that the defendant acted intentionally, knowingly, or with extreme recklessness in a way that caused the death of another person. The grand jury's determination that sufficient evidence existed to support a second-degree murder charge against both women indicated that investigators and prosecutors had built a record capable of supporting that legal threshold, a record rooted in the documented condition of Sarai's body, the timeline of her decline, and the responsibilities that both adults bore for her care. As of the date of this documentary, the case of Janae Perez and Ashleigh Utley is proceeding through the First Circuit Court in Honolulu. The jury trial is scheduled to begin on May 12, 2026, just weeks from the time this episode is being released. Because the case is currently before the court and has not yet reached a verdict, both defendants are presumed innocent until and unless a jury of their peers determines otherwise. What this documentary reports are the facts as documented in the public court record and in verified journalistic sources, the indictment, the circumstances of Sarai's discovery, and the charges brought by the state. What is not in dispute, what is documented, verified, and part of the public record, is that on June 13, 2024, a 3-year-old child named Sarai Perez Rivera was found unresponsive in a Kapolei townhouse and did not survive. What is not in dispute is that the medical examiner found the cause of her passing to be dehydration and starvation. What is not in dispute is that a grand jury, having reviewed the evidence presented by prosecutors, determined that the two adults responsible for her care should face a charge of second-degree murder. Sarai Perez Rivera was 3 years old. She had her entire life ahead of her. She should have been learning the names of colors, discovering what she loved and what made her laugh, experiencing the world in the expanding, curious way that 3-year-olds do. Instead, She spent what should have been a season of growth and joy in conditions that robbed her of the most basic requirements for survival. The full circumstances of what happened inside that townhouse will be addressed by the court in the trial ahead. Families across Oahu and across Hawaii are watching. The criminal justice system exists, in part, to ensure that when a child suffers as Sarai suffered, there is a process, transparent, evidence-based, and bound by law, through which those responsible are held to account. That process is now underway in the First Circuit Court. Whatever the jury ultimately decides, the proceeding itself represents the community's refusal to let Sarai Perez Rivera's death go unexamined and unanswered. Child welfare advocates in Hawaii have pointed to Sarai's case as a call for renewed attention to the systems designed to identify children at risk before crisis becomes tragedy. Those systems, school enrollment checks, pediatric wellness visits, neighbor awareness, and mandatory reporting frameworks, exist to create multiple opportunities for intervention. When those systems fail to identify a child in danger, the consequences are devastating and irreversible. Advocates continue to press for stronger, more coordinated approaches to child welfare monitoring in Honolulu County and across the state. Sarai Perez Rivera was 3 years old, and she deserved the protection that every child deserves. Her story is now in the hands of the court. The community she lived in will be watching to ensure that justice follows. Please like this video and subscribe to Cold Case Hour. If Sarai's story matters to you, your subscription is one way to make sure that stories like hers are never forgotten. Case 4. Ashleigh Nihipali and Kuuipo Nihipali. October 31st, 2018. First Circuit Court, Honolulu, Hawaii. Halloween is supposed to be a night of costumes and candy, of neighborhood walks and front porch lights, of children experiencing the kind of safe, community-organized joy that belongs to childhood. On Oahu, Halloween is celebrated with the same enthusiasm as anywhere else in the country. Families prepare, children dress up, and the night is marked by the kind of ordinary magic that parents remember and children carry into adulthood. On October 31st, 2018, while children across Honolulu were out trick-or-treating with their families, 6-year-old Mazen Nihipali Moniz was not among them. And the reason he was not among them is the reason this case became one of the most significant child welfare prosecutions in Hawaii's recent history. Mazen Nihipali Moniz was 6 years old, living in the care of Ashleigh Nihipali and Kuuipo Nihipali on Oahu. He was a child in a foster care arrangement, a child who had been placed in a home that was supposed to provide him with stability, care, and the kind of nurturing environment that the state's child welfare system is designed to ensure. The Nihipali household had taken on that responsibility. It was a responsibility that came with legal obligations, with oversight requirements, and with the fundamental expectation that Mazen would be safe in their care. He was not safe. On that Halloween night in 2018, emergency responders were called to the Nihipali home. When they arrived, they found Mazen unresponsive. He had sustained injuries that were not accidental, injuries that investigators, responding medical personnel, and the medical examiner who examined his condition all documented with the kind of clinical precision that forms the backbone of a criminal prosecution. Mazen Nihipali Moniz did not survive. He was 6 years old. The investigation that followed was conducted by Honolulu law enforcement with the gravity and thoroughness that the death of a child in foster care demands. The state has a heightened duty of care to children placed within its system. When a child in foster care suffers harm, the investigation is not merely about the adults in the immediate household. It is also, inevitably, a reckoning with the oversight mechanisms that were supposed to ensure the child's safety. In Mazen's case, that reckoning produced both criminal charges and broader discussions about the adequacy of foster care monitoring in Hawaii. Ashleigh Nihipali and Kuuipo Nihipali were both charged. The cases against them proceeded separately through the First Circuit Court, reflecting the different roles each woman was found to have played in the circumstances surrounding Mazen's death. Ashleigh Nihipali, whose conduct investigators determined bore the more direct connection to Mazen's injuries, was convicted of manslaughter. In December of 2020, she was sentenced to 20 years in prison. That sentence, 20 years, the same maximum imposed in the Villa case, reflected the court's assessment of the seriousness of what had occurred and the degree of responsibility Ashleigh Nihipali bore for the death of the 6-year-old boy placed in her care. Kuuipo Nihipali's case resolved through a different path. She entered into a plea agreement with prosecutors that addressed charges of child abuse and hindering prosecution. The hindering prosecution charge was significant. It pointed to conduct in the aftermath of Mazen's death that went beyond the original harm, conduct that investigators determined had been designed to obscure or complicate their understanding of what had happened. In February of 2021, Kuuipo Nihipali was sentenced to 5 years of probation as part of her plea agreement. The sentencing of both women brought a degree of legal closure to a case that had deeply shaken the foster care community in Hawaii and had prompted urgent conversations among child welfare professionals, legislators, and advocacy groups about the safeguards in place to protect children in the foster care system. Mazen Nihipali Moniz had been placed in a home that had passed whatever screening and monitoring processes were in effect at the time. He had been trusted to that home by the state, and the state's trust had been catastrophically misplaced. Hawaii's Department of Human Services, which oversees the state's child welfare and foster care systems, faced significant scrutiny in the wake of Mazen's death. Lawmakers and advocates called for comprehensive reviews of how foster homes are monitored, how frequently caseworkers conduct visits, and what protocols exist for responding to warning signs before they escalate into crises. The death of a child in foster care is not just a criminal matter. It is a systemic failure that demands a systemic response. The criminal convictions of Ashleigh and Kuuipo Nihipali were an important form of accountability. They established, through the full process of the law, that the harm Mazen suffered was not accidental, that it resulted from the conduct of the adults responsible for his care, and that the state would not allow that conduct to go unpunished. But accountability in the courtroom, while necessary, is not sufficient on its own. The deeper form of accountability, the kind that honors Mazen's memory most fully, is the ongoing, relentless work of reforming the foster care system to ensure that the next child placed in a stranger's home is protected by mechanisms strong enough to make tragedy less likely. Mazen Nihipali Moniz was 6 years old on Halloween night in 2018. He should have been trick-or-treating. He should have come home with a bag of candy and the tired, happy memory of a neighborhood adventure. He deserved that ordinary childhood joy. The system that was supposed to protect him failed him, and the legal system, at least, did not fail him in the end. His name deserves to be remembered. His story deserves to be part of every conversation about foster care safety in Hawaii. If this story resonates with you, please like this video and subscribe to Cold Case Hour. Mazen's story matters, and so does yours. Case 5, Lehua Kalua and Isaac Kalua. August 18, 2021, estimated. First Circuit Court, Honolulu, Hawaii. Isabella Kalua had a name that shimmered with the kind of warmth that Hawaii naturally evokes. She was also called Ariel, a name that, like the character it conjures, suggests a spirit full of life, full of curiosity, full of the desire to explore a world that should have been full of possibility. Isabella Ariel Kalua was 6 years old. She had been adopted by Lehua Kalua and Isaac Kalua, a couple on Oahu. She was a child who deserved everything that adoption, at its best, is supposed to provide: permanence, belonging, safety, and love. What she received instead was something that investigators, prosecutors, and child welfare advocates have since described as among the most disturbing child welfare cases in Hawaii's modern history. The estimated date of Isabella's passing is August 18, 2021. The word estimated is important here because one of the most troubling dimensions of this case is the extent to which the adults responsible for Isabella's care appear to have kept her hidden from the world. Hidden from neighbors, from community members, from any of the external eyes that might have seen her condition and raised an alarm. The reconstruction of her final weeks and months required investigators to work backward through a timeline pieced together from physical evidence, witness accounts, and the facts documented by the medical examiner. What investigators uncovered was the following. According to the indictment and the court record, Isabella Kalua had been kept in a dog crate. She had been deprived of adequate food. The combination of confinement and deprivation produced a physical condition that, by the time it was documented by investigators, was described in terms that the medical and law enforcement professionals involved found deeply disturbing. Professionals who, by the nature of their work, are not easily disturbed. The child who had been adopted into the Kalua home, who had been given a name and a family structure, had instead been subjected to conditions that stripped away every element of the safe, nurtured childhood she deserved. Lehua Kalua and Isaac Kalua were indicted for murder following the investigation into Isabella's death. The indictment represented the state's determination that the evidence was sufficient to support the most serious charge available, that what happened to Isabella was not neglect in some ambiguous or contested sense, but deliberate conduct of the gravest kind. Both defendants were charged, and the case entered the lengthy pretrial process that characterizes serious felony prosecutions in Hawaii's court system. As of April of 2026, the trial of Lehua Kalua and Isaac Kalua has not yet taken place. The proceedings have encountered a series of delays that have pushed the scheduled trial date to 2027. Both defendants are presumed innocent until and unless a jury of their peers reaches a verdict to the contrary. The case remains active, the trial date remains set, and the First Circuit Court in Honolulu remains the venue where the full evidentiary record will ultimately be presented and evaluated. Because the case is pending, this documentary will not draw conclusions about guilt or make claims beyond what is contained in the verified public court record. What is documented, what is part of the public record and has been reported by verified journalistic sources, is that a 6-year-old child named Isabella Kalua was found deceased, that the investigation produced evidence sufficient to support a murder indictment, and that both of her adoptive parents have been charged and are awaiting trial. What is also documented, and what this case has brought to urgent public attention, is the question of oversight in the adoption system. Isabella Kalua had been adopted. Her adoption had been processed through a legal framework that is supposed to include background checks, home studies, post-placement monitoring, and follow-up by the agencies and courts involved. The fact that a child who had gone through that process could end up in the conditions investigators documented is a question that Hawaii's child welfare and adoption oversight systems have had to answer publicly and uncomfortably. Child welfare advocates, lawmakers, and adoption reform specialists have been vocal about Isabella's case as a catalyst for systemic review. Post-adoption monitoring, the ongoing check-ins and welfare assessments that occur after an adoption is finalized, has been identified as an area where the systems designed to protect children can fail if they are not adequately resourced, consistently executed, and responsive to warning signs. Isabella's case has added urgency to those conversations in Hawaii and has contributed to a national discussion about what post-adoption care and oversight should look like. Isabella Ariel Kalua was 6 years old. She had a name that carried warmth and possibility. She had been given what was supposed to be a permanent home. The court will determine, in 2027, what the full weight of the evidence says about what happened to her and about the responsibility of the adults who were supposed to care for her. Until that verdict is rendered, her story remains unfinished in the legal sense. But in every human sense, her story is already complete. A story of a child who deserved protection and whose case demands that every community, every system, and every adult committed to child welfare refuse to look away. The community is watching. The court will speak. And Isabella Ariel Kalua will not be forgotten. Please like this video and subscribe to Cold Case Hour. Stories like Isabella's need to be heard. Your support helps make sure they are. Case 6. Lori Vallow Daybell. Late 2019, Kauai, Hawaii Connection. Fremont County, Idaho/1st Judicial District, Idaho, primary jurisdiction. There are cases that transcend state lines, cases whose geography is not limited to a single courtroom or a single jurisdiction, but whose facts spread across multiple places and, in the spreading, reveal the full scope of what investigators were dealing with. The case of Lori Vallow Daybell is one of those cases. It is rooted primarily in Idaho, where its most devastating facts unfolded, where the remains of 2 children were eventually recovered, and where the criminal proceedings took place. But it touches Hawaii, specifically Kauai, in a way that is documented, verified, and directly relevant to the timeline of the investigation. It is relevant to this documentary because Lori Vallow Daybell came to Hawaii during the very period when investigators in Idaho were searching for her 2 missing children, and that choice, to leave the mainland and come to the islands, became one of the most critical facts in an already extraordinary case. Tylee Ryan was 16 years old. Joshua Vallow, known to his family and to the public as JJ, was 7 years old. They were Lori Vallow Daybell's children. They were last seen alive in September of 2019 in Rexburg, Idaho. Their mother reported their disappearance in ways that investigators later described as inconsistent, evasive, and deeply troubling. The children were missing. Law enforcement in Idaho began searching. And Lori Vallow Daybell, rather than cooperating with that search, made a decision that would define the trajectory of the investigation. She left. In late 2019, Lori Vallow Daybell and her husband, Chad Daybell, whom she had married in November of 2019, just weeks after the suspicious passing of Chad Daybell's previous wife, traveled to Kauai, Hawaii. They were not there for a vacation in any ordinary sense. They were there while 2 children were missing, while investigators were actively seeking information about those children's whereabouts, while courts in Idaho were issuing orders requiring Lori to produce the children or account for their location. They were there, in Hawaii, while Tylee and JJ were gone. The image that investigators and the public were left with, a mother enjoying the beaches of Kauai while her children were unaccounted for, while law enforcement across Idaho was searching for answers, became one of the defining elements of the public's understanding of Lori Vallow Daybell. It was also, in a more concrete sense, a critical element of the investigation. Law enforcement located Lori and Chad Daybell in Hawaii. Idaho authorities coordinated with Hawaii law enforcement to serve a court order. Lori was taken into custody in Kauai in late January of 2020 for failing to comply with a child welfare order requiring her to produce her children to authorities within 5 days. In June of 2020, investigators searching the property of Chad Daybell in Rexburg, Idaho, made the discovery that the investigation had been building toward. The remains of Tylee Ryan and Joshua Vallow were recovered from the grounds of the Daybell property. Both children had been there, on the property of their mother's new husband, since the fall of 2019. They had been there while their mother was in Hawaii. They had been there while investigators searched. They had been there through the winter, through the spring, through the months of a missing persons investigation that their mother had refused to assist and had, in the view of prosecutors, actively hindered. The criminal proceedings that followed were extensive. Lori Vallow Daybell faced charges in Idaho related to the deaths of her 2 children and to additional conduct documented in the investigation. Chad Daybell faced charges as well. The trials were conducted in Idaho, in the jurisdiction where the crimes had occurred and where the evidence had been collected. In July of 2023, Lori Vallow Daybell was sentenced to life in prison. The sentence was imposed without the possibility of parole. The court's determination was unambiguous. The evidence presented and the jury's findings supported the most severe penalty the Idaho system could impose. The Hawaii dimension of this case is not incidental. It is documented. It is part of the public record. And it is part of the reason this case belongs in a documentary that examines how the choices made by people who cause harm to children can reach across geography, across jurisdictions, and across the lives of everyone connected to a family. Tylee Ryan was 16 years old. She had a future in front of her, the future of a teenager, full of becoming. JJ Vallow was 7 years old. He was, by every account offered by people who knew him, a child of exceptional spirit, a child who loved deeply and was loved deeply in return. Both children deserve to be protected by the mother who was responsible for them. Both children deserve the kind of vigilance, care, and fierce advocacy that parenting requires. What they received was the opposite of that. And when the investigation finally reached its conclusion, when the remains were recovered, when the trials concluded, when the sentences were handed down, the only comfort available was the cold, inadequate comfort of legal accountability. Lori Vallow Daybell will spend the rest of her life in prison. That is what the Idaho court determined. That is what the evidence supported. And while no sentence can restore what was taken from Tylee Ryan and JJ Vallow, it is the clearest possible signal from the justice system that the lives of those 2 children mattered, that their passing was not going to be absorbed into silence, that the adults responsible were going to be held accountable in the fullest way the law allows. Child welfare advocates and family safety researchers have pointed to this case as a stark illustration of what can happen when warning signs are not acted upon quickly, when the systems designed to protect children are navigated around by adults who understand how to exploit gaps in coordination between agencies and jurisdictions. The urgency of responsive, coordinated child welfare intervention, the kind that does not wait for confirmation before acting on concern, is one of the lessons that Tylee and JJ's story presses upon every community that hears it. Please like this video and subscribe to Cold Case Hour. Tylee and JJ deserved better. Make sure their story is heard. Case 7. Passion Quirk and Christian Rosete. April 2021. First Circuit Court, Honolulu, Hawaii. There are cases in which the facts themselves are not complicated, in which what happened to a child is, in its essential structure, a straightforward record of an infant placed in harm's way by the very adults responsible for protecting them. What makes such cases complicated is not the factual record but the human architecture behind it. The relationships between the adults involved, the agreements they made in the aftermath, and the way the legal system navigates those agreements in pursuit of the fullest possible accounting. The case of an 11-month-old infant, identified in the court record and in verified journalistic sources as Zyrex, also referred to as Pialani, is one such case. It is a case about a baby who could not speak, who could not report, who could not protect themselves in any way, and who was subjected to harm in the one place that should have been the safest environment in their world, their own home. In April of 2021, on Oahu within Honolulu County, the 11-month-old infant was found to have sustained injuries of a nature that prompted an immediate medical and law enforcement response. The infant was in the care of their mother, Passion Quirk, and Quirk's partner, Christian Rosete. The investigation that followed focused on reconstructing the circumstances under which the infant's injuries had occurred, who was present, what had taken place, and what role each adult in the household had played in the harm the child had suffered. The investigation produced a picture that required the legal system to make a series of difficult determinations about relative culpability. Passion Quirk, the infant's mother, had been present. Christian Rosete, her partner, had been present. The injuries to the 11-month-old were documented by medical professionals with the precision that such cases require, and investigators built their understanding of the case around that medical record and around the accounts eventually provided to them through the legal process. The case resolved through a plea agreement structure that reflected the evidentiary realities and the prosecutorial strategy pursued by the state. Passion Quirk entered a guilty plea to assault charges. As part of that plea agreement, she agreed to cooperate with the prosecution of Christian Rosete to provide testimony against her former partner in exchange for a negotiated resolution of her own case. The decision to pursue this structure reflected the prosecution's assessment that Rosete bore the primary responsibility for the infant's most serious injuries, and that Quirk's cooperation was essential to building the evidentiary foundation needed to hold Rosete fully accountable. Christian Rosete's prosecution moved forward with the benefit of that cooperation. The case against him was presented to the court, and the outcome was one of the most significant sentences handed down in a child harm case in Hawaii in recent years. In February of 2025, Christian Rosete was sentenced to 45 years in prison. 45 years, a sentence that, in practical terms, represents the overwhelming portion of a working adult's remaining life. A sentence that the court imposed in recognition of the severity of what Rosete had done to an infant who was 11 months old, entirely defenseless, and entirely dependent on the adults around them. Passion Quirk's own case resolved in October of 2024. She was sentenced to 4 years of probation. The probation sentence reflected both the terms of the plea agreement reached with prosecutors and the court's assessment of her role in the case relative to Rosete's. It also reflected the reality that the legal system frequently navigates complex situations in which multiple adults bear different degrees of responsibility for harm to a child, and in which the full accountability of the most culpable party sometimes requires the cooperation of others. The outcome of this case, 45 years for Rosete, 4 years probation for Quirk, will be assessed differently by different members of the public. Some will see the sentence structure as appropriate, reflecting the evidentiary findings and the prosecutorial strategy that produced the most substantial accountability for the primary perpetrator. Others will argue that any adult present when a child is harmed bears a level of responsibility that demands stronger consequences. These are legitimate conversations for communities, for legislators, and for child welfare advocates to have, and they are conversations that this case, like so many others, has helped to prompt. What is not subject to debate is what happened to the 11-month-old at the center of this case. An infant who had done nothing to deserve harm, who was living in the care of the adults responsible for their safety, suffered injuries serious enough to generate criminal charges that resulted in a combined prison sentence of 45 years. The legal system's response to that harm was, ultimately, substantial. The conversation about how to prevent such harm from occurring in the first place, about the resources available to young families, about the warning signs that might precede such events, and about the community structures that can provide support before crisis becomes tragedy, is one that deserves continued, serious attention. The 11-month-old at the center of this case deserve protection. They deserve to grow up in safety. The court's response, particularly the 45-year sentence imposed on Christian Rosete, represented a clear statement from the judicial system about the value of a child's safety and the consequences that follow when that safety is violated. Please like this video and subscribe to Cold Case Hour. This baby deserved a voice. Thank you for being part of the community that makes sure these stories are heard. Case 8, Sina Pili. December 22, 2023. First Circuit Court, Honolulu, Hawaii. Lehua is a community on the northeastern shore of Oahu, a place known for its university, its cultural center, its tight-knit community bonds, and the kind of neighborhood familiarity that residents and visitors alike associate with the more peaceful rhythms of island life. It is not a place where the events that came to public attention in December of 2023 would have been anticipated. It is not a place where the name of an 11-year-old girl named Ashleigh Pili you should have entered the records of a criminal investigation. And yet it did. And the details of what investigators documented in the Lehua home where Ashleigh lived, the home of her adoptive mother, Sina Pili, are precisely the reason this case belongs in any serious examination of child welfare failures in Hawaii. On December 22, 2023, emergency responders were called to a residence in Lehua. Ashleigh Pili, 11 years old, was found unresponsive. The medical response was immediate. The findings that emerged from the examination of Ashleigh's condition were deeply troubling. Investigators documented injuries consistent with strangulation and with conduct that the court would ultimately classify as first-degree assault. Ashleigh had been harmed in her own home, in the place where she was supposed to be most safe, by the woman who had adopted her and who bore legal and moral responsibility for her well-being. Sina Pili was Ashleigh's adoptive mother. She had taken on the legal and parental responsibility for this child through the adoption process, a process designed, as with all adoptions, to ensure that children are placed in homes where they will be cared for, protected, and given the stable, loving environment that every child deserves. Ashleigh had been placed in Sina Pili's home with the expectation that she would be safe there. The investigation into her condition revealed that she was not. The case moved through the legal process with the seriousness it demanded. Sina Pili was arrested and charged with first-degree assault. The charge of first-degree assault in Hawaii is reserved for conduct that causes serious bodily harm. The law's recognition that what was done to Ashleigh was not minor, not ambiguous, and not a matter that the legal system would treat as anything less than a major criminal offense. On April 15, 2026, Sina Pili appeared before the First Circuit Court and entered a guilty plea to the charge of first-degree assault. That plea, entered just weeks before the date of this documentary, represented an acknowledgement through the legal process of criminal responsibility for what was done to Ashleigh Pili. The guilty plea removed the need for a trial, and the case is now proceeding toward the sentencing hearing scheduled for July 29, 2026. Because sentencing has not yet occurred at the time of this documentary, the consequences that Sina Pili will face for her conduct have not yet been fully determined by the court. What has been determined, through the plea process, through the legal record, and through the documentation produced by investigators, is that criminal responsibility has been established. The court will determine the appropriate sentence in July, and the community will be watching. The case of Ashleigh Pili has become part of the ongoing conversation in Hawaii about post-adoption oversight, the same conversation that Isabella Kalua's case has prompted, and that runs through so many of the cases documented in this episode. Adoption is one of the most profound acts of commitment that adults can make to a child. It is a legal and moral declaration that a child is yours, that their well-being is your responsibility in the fullest sense of that word. When adoptive parents harm the children placed in their care, it is a violation not only of the law but of the most fundamental promise that adoption represents. Ashleigh was 11 years old. She was at an age when children begin to develop a sense of themselves in the world, their interests, their friendships, their sense of who they are and who they might become. She deserved to develop that sense in safety and in the knowledge that the adults responsible for her would protect her. The court's process will continue through July of 2026, and the community that knew Ashleigh, the Laie neighborhood, the broader Oahu community, and the child welfare advocates who have followed this case will be present when that sentence is handed down. The legal system is doing its work. The community's work of remembering Ashleigh, of pushing for stronger post-adoption monitoring, and of holding every adult responsible for a child to the standard that responsibility demands, is ongoing. Ashleigh Pili was 11 years old. Her name deserves to be remembered. Her story deserves to be part of every conversation about how Hawaii protects the children in its care. Please like this video and subscribe to Cold Case Hour. Ashleigh's story deserves an audience. Your support makes sure it gets one. Case 9. Brandy Kanani Blas and Debra D. Geron. January 18, 2024. First Circuit Court, Honolulu, Hawaii. Wahiawa is a town near the center of Oahu, a community with a long history, a strong sense of local identity, and the kind of residential neighborhoods where children should be able to grow up in safety. It is not a community where the events that investigators documented in January of 2024 should have occurred. It is not a community where the name of a 10-year-old girl named Gianna Bradley should have entered the court record in the way that it did. But on January 18, 2024, Gianna Bradley was found deceased in a home in Wahiawa, and the investigation that followed produced findings that resulted in some of the most serious criminal charges that the First Circuit Court in Honolulu has seen in connection with child welfare in recent years. Gianna Bradley was 10 years old. She was living in the care of Brandy Kanani Blas, her foster mother, in a Wahiawa residence. Also implicated in the circumstances of Gianna's death was Debra D. Geron, Gianna's grandmother, who was also connected to the household and to the care arrangements under which Gianna was living. When emergency responders arrived on January 18th, they found Gianna unresponsive. She was pronounced deceased. The medical examiner who examined her condition produced findings that would become the foundation of the criminal case to follow. The medical examiner's findings, as documented in the public record and reported by verified journalistic sources, described the cause of Gianna's passing in terms that the court record summarizes as multiple effects of prolonged child abuse and neglect. That phrase, prolonged, is one of the most important and most devastating words in the legal record of this case. Prolonged means that what Gianna experienced was not an acute event, not a sudden crisis, not a single moment of terrible judgment that produced an unintended outcome. Prolonged means that the conditions under which Gianna was living had been in place over a period of time, an extended period during which her condition deteriorated, during which her body suffered the compounding consequences of deprivation and harm, and during which no intervention occurred. The medical record documented evidence of starvation. It documented evidence of blunt force injuries. The combination of these findings, each serious in its own right and devastating in combination, painted a picture of a child who had been suffering in ways that any attentive adult present in that home would have been aware of, and who had not received the intervention, the medical care, or the protective response that her condition demanded. Brandy Kanani Blas and Debra D. Geron were both arrested and charged in connection with Gianna's death. In February of 2024, approximately 1 month after Gianna's body was discovered, a grand jury returned indictments against both women. The charge was second-degree murder, the same legal threshold that applied in the Perez Utley case. The state's determination that the evidence supported a finding of intentional, knowing, or extremely reckless conduct that caused the death of another person was applied here, and the grand jury found that threshold met. As of the date of this documentary, the case of Brandy Kanani Blas and Debra D. Geron is awaiting trial. Both defendants are presumed innocent until and unless a jury reaches a verdict to the contrary. The case is proceeding through the First Circuit Court, and the full evidentiary record will be presented in trial proceedings whose date has not yet been publicly announced. The community in Wahiawa, the foster care advocacy community in Hawaii, and the broader network of child welfare professionals watching this case are all awaiting the opportunity to hear that evidence presented and evaluated in open court. What is already part of the public record, documented, verified, and not subject to dispute, is that Gianna Bradley was found deceased in a Wahiawa home on January 18, 2024. What is documented is that the medical examiner attributed her passing to the effects of prolonged child abuse and neglect. What is documented is that the grand jury determined the evidence sufficient to support second-degree murder charges against both of the women responsible for her care. Gianna Bradley was in foster care. She was, like Mazin Kaniela Nihipali Moniz, a child whose placement in a foster home was supposed to represent the state's commitment to her well-being. She was a child who had been entrusted to the care of adults operating within the foster care system, a system with its own framework of oversight, its own requirements for monitoring, and its own obligations to the children placed within it. When a child in that system is found in the condition investigators documented in Gianna's case, it is not possible to treat that finding as a private tragedy. It is a public failure, a failure of the system, of the oversight mechanisms, and of the adults whose responsibility it was to ensure that Gianna was safe. Hawaii's foster care system has faced sustained scrutiny since Mazin Kaniela Nihipali Moniz's case in 2018. The emergence of Gianna Bradley's case in 2024, just over 5 years later, involving another child in foster care, another household where prolonged harm went undetected, another grand jury indictment for serious criminal conduct, has intensified those calls for reform. Advocates have pressed for more frequent in-person check-ins with foster children, for increased resourcing of caseworker positions that are chronically understaffed, and for stronger coordination between the Department of Human Services, law enforcement, and community organizations with existing relationships in neighborhoods where foster children live. Gianna Bradley was 10 years old. She had been placed in a home that was supposed to be safe. She deserved the protection that the foster care system promises every child placed within it. The court will have the opportunity to render its judgment when this case comes to trial. The community has already rendered its own. Gianna Bradley mattered. Her suffering was not invisible in retrospect, even if it was unaddressed in the moment, and the systems that failed her must be changed so that the next child placed in a foster home in Wahiawa, and everywhere else in Hawaii, is better protected. Please like this video and subscribe to Cold Case Hour. Gianna's story is one that every community in Hawaii needs to hear. Thank you for being part of the audience that makes sure it is heard. Case 10, Chasity Alcosiba-McKenzie. July 25, 2017. Third Circuit Court, Hawaii Island, Kona/Hilo Division. The island of Hawaii, the Big Island, as it is known colloquially, is the largest land mass in the Hawaiian archipelago. It is home to communities spread across its sweeping geography, from the lava fields of its western coast to the rainforests of its eastern shores, from the summit observatories of Mauna Kea to the coastal neighborhoods, where families live in the rhythms that island life creates. Kalua, on the western side of the island, is one of those communities, a place where families put down roots, where children grow up with the ocean nearby, and where the expectation of safety in one's own home is as fundamental as it is anywhere else in Hawaii. On July 25, 2017, that expectation was shattered for a family and a community when a 3-year-old boy named Fabian Garrett Garcia did not survive the day. Fabian Garrett Garcia was 3 years old. He was a toddler at the age of discovery, the age when children begin learning how the world works, how to run and jump and ask endless questions, how to be in a family and in a community with a growing sense of their own presence in both. He was a child who should have had years ahead of him. On that July day in 2017, Fabian was in the care of Chasity Alcosiba-McKenzie. He was not in his own home. He was in the care of a caregiver, a woman who had taken on the responsibility of keeping him safe while the adults responsible for him were otherwise occupied. That responsibility was not honored. Fabian sustained head injuries while in the care of Alcosiba-McKenzie. The medical examination of his injuries, conducted with the thoroughness that cases involving children always demand, produced findings consistent with what investigators and prosecutors would describe as non-accidental harm. Injuries to the head of a nature and severity that the medical record indicated could not be attributed to an accident or to the ordinary physical incidents of a 3-year-old's active daily life. Fabian Garrett Garcia did not survive his injuries. He was 3 years old. The investigation was conducted by law enforcement on Hawaii Island and produced the evidentiary record that formed the basis of the prosecution of Chasity Alcosiba-McKenzie. She was charged with manslaughter in connection with Fabian's death, the same charge that had been brought in other cases in this documentary, where the state determined that the evidence supported a finding of criminal conduct causing a child's death without meeting the higher threshold of an intentional murder charge. The case proceeded through the Third Circuit Court on Hawaii Island. The prosecution presented its evidence. The legal process ran its full course. Chasity Alcosiba-McKenzie was convicted of manslaughter. In February of 2022, she was brought before the court for sentencing. The judge, having considered the facts of the case, the nature of the harm inflicted on a 3-year-old child, and the circumstances of the conviction, imposed a sentence of 20 years in prison. 20 years. The same maximum manslaughter sentence imposed by the First Circuit Court in Honolulu in the cases of Ashleigh Nihipali and Dixie Denise Villa. The courts across Hawaii's jurisdictions have, in their separate determinations, arrived at the same place when confronted with the most serious cases of fatal harm to children in a caregiver context, a recognition that the maximum the law provides is the appropriate response to the worst that the law must address. The sentencing of Chasity Alcosiba-McKenzie in February of 2022 represented the legal system's judgment on the events of July 25, 2017. It closed, in the formal legal sense, the prosecution's effort to hold accountable the person responsible for Fabian Garrett Garcia's passing. What it did not close, what the cases in this documentary collectively refused to allow to close, is the conversation about childcare safety, caregiver accountability, and the obligations that anyone who accepts responsibility for a child takes on in the most serious possible sense. Child care providers, licensed or unlicensed, professional or informal, familiar to the family or newly known, occupy a position of profound trust when they accept care of a child. Parents who hand their children to a caregiver are making an act of trust rooted in the belief that the person receiving their child will protect that child with the same commitment they would bring to their own. When a caregiver violates that trust, when a child suffers harm in the place that is supposed to be safe, the consequences cascade outward, through the family, through the community, and through every future act of trust that parents must perform when they place their children in someone else's care. The legal accountability imposed on Chasity Alcosiba-McKenzie by the Third Circuit Court was an important and necessary response to those consequences. 20 years in prison for the harm done to a 3-year-old child represents the justice system's clearest possible statement that Fabian Garrett Garcia's life had value, immense, irreplaceable value, and that the person responsible for ending it would be held accountable for the full weight of that loss. Fabian Garrett Garcia was 3 years old. He was a toddler on the cusp of everything that childhood becomes. He deserved the afternoon, the evening, the years that followed, the life that was taken from him on a July day on the Big Island. His name deserves to be spoken in every conversation about caregiver accountability in Hawaii. His case deserves to be part of every training, every licensing review, every policy discussion about how this state protects its youngest and most vulnerable residents. The accountability was delivered. The sentence was imposed. The memory of Fabian Garrett Garcia, 3 years old, full of the energy and curiosity of a toddler at the beginning of everything, belongs now to the community that is determined not to forget him, and to the advocates who carry his story forward as a reason to make the systems that are supposed to protect children stronger, more vigilant, and more uncompromising in their commitment to every child they exist to serve. This documentary has examined 10 cases, 10 children, 10 failures of the duty of care, 10 instances in which the legal system of Hawaii was called upon to respond to the worst possible outcomes. Across every case in this episode, one truth remains constant. Children cannot protect themselves. They depend entirely on the adults around them, parents, caregivers, foster families, adoptive families, community members, and the systems that all of these adults are embedded within, to see them, to protect them, and to put their safety above every other consideration. If you are concerned about the safety of a child in your community, you can contact the Child Help National Child Abuse Hotline at 1-800-4-A-CHILD, available 24 hours a day, 7 days a week. In Hawaii, the Department of Human Services Child Welfare Services branch can be reached through the statewide Child Abuse Hotline. You do not need certainty to call. Concern is enough. A phone call can save a life. The 10 children whose stories were told in this episode deserve to be remembered. Abigail Lobish, Peter Boy, Kema Jr. Sarai Perez Rivera, Mazin Kaniala Nihipali Moniz, Isabella Ariel Kalua, Tylee Ryan, Joshua J.J. Vallow, the infant at the center of Case 7, Azalea Piliayu, Gianna Bradley, Fabian Garrett Garcia. Their names deserve to be spoken. Their stories deserve to be heard. And the communities they came from deserve a future in which the systems responsible for protecting children are strong enough, responsive enough, and committed enough to ensure that no other child suffers what they suffered. Thank you for watching Cold Case Hour. If this documentary meant something to you, if these children's stories moved you the way they should move every person who hears them, please take a moment to like this video, leave a comment below, and subscribe to Cold Case Hour so that you never miss another episode. Every like, every comment, every subscription tells us that this work matters. It tells the families of these children that their loved ones are not forgotten. And it tells us to keep going, to keep telling the stories that deserve to be told, with the seriousness and the respect that every victim in every case deserves. Like, comment, subscribe, and we will see you in the next episode.